Abusia breaking news ayensa kan and said the former finance minister Ken Ofori-Atta has been redeclared wanted by the office of the special prosecutor. Na animu ya manuguso amenu twetwe nkomo special prosecutor have a press brief ewo the office of the special prosecutor or chemu say Ken Ofori-Atta a lawyers for amane ba mo de bo OSP ni chepe fe say won pese obedi ani die mema the office enkonkodan chen so masa commence the extradition process abia Yewra OSP wo bia no ye bono aba o man Ghana me dini asem wa say die we can confidently say Office of the Special Prosecutor issue Interpol red notice Yewra Ken Ofori-Atta and you may bear dancing or two yanajibre na yenti Yewra Kisia Jaben wa bra.
Lawyer stated further that in order not to hold the office back in the performance of his function, they had Mr. Ofori-Atta's instructions of his readiness to go through video recorded interview for the purpose of eliciting his caution statement. His lawyers offered to meet the special prosecutor in person or approach the bench for the purpose of viewing Mr. Ofori-Atta's biopsy report, whichever suited the special prosecutor. Now, ladies and gentlemen of the media, this is where we are now. And let us step back a bit from the 28th May 2025 letter from Mr. Ofori-Atta's lawyers and place the matters in their proper context. I have intentionally went through a tedious timeline. The letter from Mr. Ofori-Atta's lawyers, dated 18 February 2025, clearly indicated that the possible surgical intervention to be performed on him was to occur on 20 and 21 March 2025, upon which reckoning the OSP carefully considered the recovery period and indulgently pushed Mr. Ofori-Atta's attendance at the OSP to 2 June 2025. Therefore, Mr. Ofori-Atta had a duty to promptly inform the OSP of any fundamental change in his medical circumstances on 21 March 2025, when the advertised surgical intervention was not performed, to enable the OSP reschedule a new date of his attendance at the OSP to accommodate any such material changes in his medical condition and treatment itinerary. Mr. Ofori-Atta has known, at least since 21 March 2025, that no surgical procedure was to be performed on him in March. Yet, he purposely sat by indolently and chose not to inform the OSP of such fundamental changes in his circumstances. Instead, about 67 days after learning of the alleged changed circumstances around 21 March 2025, Mr. Ofori-Atta elected to spring a surprise on the OSP on 28 May 2025, just 6 days before his scheduled attendance at the OSP, by offering to undergo a video recorded interview and a viewing of his biopsy report. Now, back to the 28 May 2025 letter from the lawyers of Mr. Ofori-Atta. As I said, this is where we are. By a letter dated 30 May 2025, the OSP declined Mr. Ofori-Atta's offer of video recorded interview for the purpose of eliciting his caution statement. This office has always insisted on his personal attendance, and we have indicated clearly to him that we are unwilling to waive it. If we were amenable to taking any such statement from Mr. Ofori-Atta in absentia, we would have done so in February and not waited to 2 June 2025. We want him here physically, and we insist on it. A suspect in a criminal investigation does not pick and choose how the investigative authority should conduct its investigations and the method suitable to him and his convenience. We will not countenance such conduct, not in this case or in any other case. Further, the OSP has declined Mr. Ofori-Atta's invitation to view his biopsy report, as we consider it a pointless exercise. This is because it is common learning that the biopsy report contains nothing more than a conclusion upon the removal and examination of tissue, cells, or fluids from a living body that some disease or malady was indicated in the samples taken. A biopsy report is not an expression of a reasoned medical opinion that the subject of the report is an invalid and unable to travel, as Mr. Ofori-Atta seeks to suggest is his condition, and for which reason he says he cannot return to the jurisdiction. This much is clear. Since 24 January 2025 till date, Mr. Ofori-Atta has failed to show any medical report. I underline, he has failed to show any medical report which suggests that he is a travel risk and unable to return to the jurisdiction by reason of his medical condition. It has all been his say-so, his singular say-so. Therefore, the OSP views Mr. Ofori-Atta's lawyer's letter dated 28 May 2025 as an expression of utter bad faith on the part of Mr. Ofori-Atta, and it confirms our long-held, well-considered opinion and conclusion that Mr. Ofori-Atta has no intention of voluntarily returning to the jurisdiction and to attend the OSP. Further, this office is unaware of his purported information to the court, whether orally or by filed processes, of the alleged change in his circumstances. Today is Monday, 2 June 2025. It is more than 3 hours past the scheduled time of Mr. Ofori-Atta's attendance at the OSP, and Mr. Ofori-Atta failed to attend the OSP today. Mr. Ofori-Atta's conduct is totally unacceptable and a baleful spite at law enforcement and criminal investigations. It ends here. It ends today. We will no longer accommodate him. Consequently, the OSP redeclares that Mr. Ofori-Atta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Ofori-Atta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Ofori-Atta, pending extradition or his surrender. Around the same time, I dispatched a request for extradition processes to be instituted for the provisional apprehension in any jurisdiction. This extradition to the Republic of Ghana. The OSP will prefer criminal charges in the courts against Mr. Ofori-Atta in due course, whether in absentia or otherwise. The principle upon which we proceed is that no person, regardless of title, regardless of status, regardless of medical, is beyond the reach of inquiry by the OSP. Thank you.
My name is Hansen Aguman. I work with Channel 1 TV City FM. On the issue relating to the former finance minister,
I talked about 4 cases. Why did you go there first?
We wonder what difference will his presence make for the OSP? Because, again, as you've indicated, you have even the option of trying him in absentia. And if you have enough case against him, you can go ahead even without his presence. What exactly is the OSP interested in getting the finance minister back? Relating to the NPA case, you said that you give out the names of who did what at the right time.
When we file?
Yes, when you file. But I remember at the last press conference, you had singled out the former CEO of the NPA in the person of Mustafa Hamid. It's fair to ask, is he part of the issues you outlined here today, or his is different? Because he had come out to say that you have not even engaged him, you've not notified him of
is that so?
Yes, of any form of interrogation, and he's not done anything wrong. Thank you. And the final thing with Cecilia Dapa is it that you disagree? Because we know that Ioko's stance on the matter was based on an advice from the former Attorney General, who says that if you look at the reading of the law, money laundering should be on a predicate offense. Is it that the Office of the Special Prosecutor disagreed with that legal view?
Can I answer? Then we go.
Is there any more questions so that we are clear that...
You know, let me override you. Sometimes when it's fresher in mind, the responses come quick. By the time I take 20 questions, I'll forget the meat of what he said. What is his presence? What will his presence do? Now, as I said, in due course, we will charge him, whether in absentia or otherwise. Imagine we charge him in absentia and we get a conviction against him. Who are we imprisoning or who are we fining? Say, to get a simple mathematics of it. As I said in my brief, a suspect in a criminal matter does not choose how the investigative authority should go about investigating him. When he wants to appear, when he decides to appear, in what way he wants to appear. We do not take caution statements online from a foreign jurisdiction. You get me? And who says I even want to take a caution statement from him? He is the one who is dictating, he wants to dictate the process. You get it? And we have always insisted from the onset that we want him here. Legally, I will say that to you. But there's a far more grave reason why we need him here. And since the investigation is still going on, it will be rounded up soon. I will not be able to disclose it to you. But as I said, that possibility, if we take him to court, if he is convicted, if he is sentenced to some number of days, months, years in prison, in absentia, what would we have done if we didn't take steps to bring him here? Mind you, this office investigated a former president. The former president was served at the time with the same kind of directive to appear before the OSP. We didn't have to be chasing the former president around the world, how much less a former minister for finance. What is so special about Mr. Ofori-Atta that he thinks he's unique and should be treated like a king? As I said, we have indulgently accommodated him. It ends here. It ends here today. This rigmarole is not going to go on anymore. We are not going to accommodate such conduct again. We've granted him so long a rope, it's tied him up, and it's done. Our NPA, yes, we singled out 3 individuals on 12 February. And you said one said he hadn't been engaged. Or let me ask my operational directors, should I review? They say no. So when we file, as I said, we will go through, we will brief you who did what, who took what, who acquired what, and what we've been able to identify and what we've been able to retrieve so far. We've retrieved some things too. Cecilia Dapa, when in May 2024, the then head of IOCO returned the docket back to the OSP. The OSP didn't comment, did it? We didn't express an opinion as to whether we agreed with its conclusion or otherwise, or as to whether we agreed with the Attorney General then. We had investigated the matter. We had hit a wall in terms of our mandate. We were seeing things that looked like in the province of IOCO's mandate. So we sent the docket to IOCO under referral, under provisions under our act. Not for them to go to court, because we didn't think the docket was ready for prosecution. What we suggested was do your own investigation, commence your own investigation to see if you will see conclusions of what we think we are seeing. They returned it to us wholly and said they didn't have any basis upon which to commence investigation. Now a year later, there's a new leadership. The new leadership has requested for the docket that they want to review and commence investigation. So we've given it back to IOCO under the new leadership, and we have promised them our full collaborative support and partnership in respect of their review and investigation. Shouldn't you be happy that someone wants to take action and not someone who just closes a file and says, I can't even open up to investigate. Yes. Yes, sir. Did I see you this morning?